Now, the High Court has once again punched holes into the clamour for constitutional reforms by barring President Uhuru Kenyatta from assenting to the BBI bill should it be passed by Parliament. In the ruling, the five-judge bench that has been hearing consolidated petitions against the process issued conservatory orders preventing action by the President until determination of the petitions. KTN's Ibrahim Karanja has those details.
2021 by the five-judge bench comprising of Justices Joel Ngugi, George Odunga, Jairus Nga, Chacha Mwita and Teresia Madheka had barred the Independent Electoral and Boundaries Commission IEBC from subjecting Kenyans to a referendum on the Constitution of Kenya Amendment Bill 2020 pending the hearing and determination of consolidated petitions challenging the BBI process. However, legislative houses, including the 47 county assemblies, the National Assembly and the Senate, had the green light to proceed with their roles. The ruling, it appears, may have tactfully been avoided by proponents of the constitutional reforms by employing Article 256 Subarticle 4 that allows the President to assent to constitutional amendment bills if the items to be amended are not protected under Article 255 Subarticle 1 of the Constitution. Among the items protected under Article 255 Subarticle 1 of the Constitution are the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, national values and principles of governance referred to in Article 10, Subarticle 2, Clause A to D, the Bill of Rights, the term of office of the President, the independence of the judiciary and the commissions and independent offices to which Chapter 15 applies, the functions of Parliament, the objects, principles and structure of devolved government or the provisions of this chapter. The jury is still out if any of these items have been altered in the BBI draft bill. If not, that would give leeway for a presidential assent without a referendum.
The invitation by the applicants in the present application is for the court to consider the alternative tail end. This is where the President determines that all the matters canvassed in the Constitutional Amendment Bill are not protected matters under Article 255 and that therefore, they do not need to be sent for a referendum.
In their application, Third Way Alliance argued that should the President use this alternative route, then the earlier orders and the subsequent ruling on the consolidated petitions would be null and void.
The assent contemplated under Article 256, Subarticle 4 of the Constitution, if it were to be given to the Constitutional Amendment Bill 2020, shall not come into force until the determination of these consolidated petitions.
The court, however, stated that it would expeditiously dispense with the petitions. Meanwhile, in Parliament, the Justice and Legal Affairs Committee has downplayed any claims of division amongst its members.
Clearly, that there are no divisions among us, right? We are working as a united group in this joint committee. So any speculation that by the media or anybody else, we refute it here.
We want to give a product to Parliament, not one to Senate and another to the National Assembly. We want to produce a product that will guide Parliament.
The Under Fire Joint Committee has stated that it will engage experts before finally tabling reports on the BBI bill. Ibrahim Karanja, KTN News.
And now the Kenya Certificate of Secondary Education, KCSE,